I'm a former New York State Supreme Court Justice. Let me tell you about a real case story. A city bus was entering Central Park through the Traverse to get from the west side to the east side. It came to a bend in the road and started to make a right turn, when suddenly a passenger on the bus yells out, "Stop the bus! You just hit a young man on a bicycle." Sure enough, there was a young man on the ground next to the bicycle. The passenger spoke to another passenger saying, "Look, I can't remain. I've got to get out of here. I'm late for work, so I'm going to leave the bus, but I'm going to write out the note, what I saw, and I want you to give this to the police." And she writes the note, and she gives this note to the passenger. When the police arrive, the passenger gives this note to the police. Well, the note reads as follows. "I was sitting in the back of the bus, and as the bus made this right turn in the bend, I saw that the rear of the bus struck a young man on a bicycle, and he fell to the ground. And I yelled out to the bus driver, 'Stop the bus, you just hit a young man on a bicycle.'" Well, we were retained. We tried to find this young woman who actually signed that note. We put out investigators. We couldn't find her. There was no way of locating her. The investigation came back zero. It's as if she evaporated from the earth. She was gone. And all we had was this note. Well, we ultimately went to trial. But any statement that's made out of court is a hearsay statement. I will not go into all of the details of the law of evidence as if we're in a law school. Suffice to say that it was a hearsay document, and hearsay documents, with few exceptions, are not accepted or admitted into evidence. And unless we could get that piece of paper into evidence, we'd have no case. Well, we argued before the judge when we tried to introduce that piece of paper that actually this represented one of the exceptions to the hearsay rule. That exception being a contemporaneous utterance at the time of the accident. I won't go into the various legal details. Suffice to say, the other side, the Assistant Corporation Counsel, argued vociferously that this was rank hearsay, should not be admitted under any circumstances. We finally prevailed, and the judge marked it into evidence. Well, the jury took the case and ultimately decided the case. It so happened that the young man was a dentist. The accident fractured his right arm. We claimed that he suffered great pain and suffering. We claimed further a disability, a loss of income, and future difficulties in his practice. Jury came back with a substantial verdict considering all of those elements. And were it not for that piece of paper, that trial would never have been won. Well, that's it. This is a storyteller telling you, stay safe and keep out of danger.